Welcome to Veranda IAS. In today's session of Polity Current Affairs, we are going to discuss about contempt of court. So the learning objective of today's session is to explain the contempt of court, what is mean by contempt of court, examine the contempt of court in news. So this contempt of court is not a new thing. This is in there from 1950. So why are we studying this in current affairs? So discuss its relevant provisions. Under what provisions the judiciary is having such contempt powers, the powers to punish its contemptors. Analyze the reasons why courts need such contempt powers and list the issues associated with this contempt laws. So first, what is contempt of court? An introduction. So contempt of court is one of the most contentious issues in Indian law. Time and again, there is a tussle between judiciary and some other people, particularly media persons, using this contempt of court issues. While the main purpose of a contempt statute, contempt law, is to penalize the people who violate court orders, in the Indian context, contempt is also used to punish the speech which actually diminishes the court's dignity, which lowers the court's dignity and obstructs the administration of justice. So apart from India, what does contempt of court mean in other countries? It means punishing the people who are violating the court orders. There is no concept of punishing the people for their remarks on judiciary, for their criticisms on judiciary. But here we have two types of contempt in which the judiciary can punish for willful disobedience, and also the judiciary can punish a person who is criticizing the judiciary, who is misquandering. The dignity of the judiciary has to be maintained at any cost. Yes, there is no doubt in that. So in order to do that, the judiciary should be having some minimum power to punish the person who is actually going against damaging the dignity of the judiciary, right? So that is what the context of Indian court's power to punish. Civil contempt is the willful disobedience of a court order or judgment, or the willful violation of a court ordered duty. If there is civil contempt, there will be a criminal contempt also, right? So what is criminal contempt? That is what I said here. Criminal contempt is a action or speech which diminishes the court's dignity or obstructs the administration of justice. So there are two types of contempts. One is civil contempt and another one is criminal contempt. So why this contempt of court is in news? On August 2020, the Supreme Court of India initiated a contempt proceeding against famous Supreme Court advocate Prashant Bhushan. See, there are two ways in which this contempt proceeding can be initiated in a Supreme Court. First one is by suo motu, which means nobody has to petition the Supreme Court. The Supreme Court themselves will start the petition. They themselves will start the process. That is what suo motu. And the second process by which a private person can approach the Supreme Court, can file a case in Supreme Court, this contempt petition against any other persons. But for that, they have to obtain the consent of Attorney General or in case Solicitor General previously. Without their consent, this contempt petition will not be admissible in Supreme Court. So the court initiated the proceedings in response to a petition alleging that Prashant Bhushan has made two tweets in the preceding 2 months. So the tweet made by Prashant Bhushan resulted in contempt proceedings. So the lawyer made comments in the tweets criticizing the then Chief Justice Sharath Arvind Bobde, SCA Bobde, and the court's overall functioning under the previous 4 Chief Justices. The court stated that the tweets constituted prima facie contempt. So it appears there is a prima facie, it appears that this person has tweeted this with criminal intent, that is lowering the dignity, attacking the dignity of the Indian judiciary. So what are the relevant provisions present in Indian constitution for this contempt powers, power to punish its contemptors? There are two articles, two important articles, Article 129 and Article 250. So Article 129 and 215 of the Indian Constitution enables the Supreme Court and the High Courts to penalize the individuals for contempt. So Article 129 is for Supreme Court and Article 215 is for High Courts. Using these powers, the judiciary can punish any person for contempt of court. Contempt of court is also included in the Constitution's list of justifiable restraints, which means reasonable restrictions. Reasonable restrictions. So this contempt of court is also included in the list of Constitution's list of justifiable restraints on freedom of speech and expression under Article 19. See, Article 19 lists those various rights. In that, one such right is right to speech and expression, but that is not absolute right. There are certain restrictions, reasonable restrictions are provided. So what are all those restrictions? So decency, maintaining the public morality, incitement to violence, maintaining the friendly relationship with neighbor countries. So your speech should not hamper these all. And also in that, one such ground is contempt of court. On this ground, on the ground of contempt of court, any person's right to speech can be curtailed. So these are the constitutional provisions. And why do these courts need power to punish the person for its contempt? So what is the need of such power? To guarantee that their directives are carried out. The judiciary is the supreme authority, you can say. It even questions the government. It even nullifies the act passed by the parliament. So in that sense, there has to be a respect attached to the orders of such judiciary. So for that, this minimal power is required to maintain the judiciary's independence. While the judiciary issues orders, the government or private parties carry them out. If courts are unable to carry out their judgments, the rule of law would come to a grinding halt. See, if courts are issuing some judgments or orders and nobody is respecting that order, then what is the point of having a court? And what is the point of having an independent judiciary? What is the point of calling it as even independent? Is that powerful? No. So it will be like a bolt to the democracy. So that is why a minimal power should be vested with the hands of judiciary to enforce their own orders. So what is civil contempt? Willful disobeying of the court's orders is the civil contempt. So if anybody is not obeying the orders of judiciary, Supreme Court, it may be union government, it may be state government, or it may be a private persons. It can even punish the union government for contempt of court. If the union government is not carrying out the directions of the Supreme Court, they can even fine an amount, or they can ask explanation from whatever secretary or who is responsible for that. So this is why the power to punish the contemptors is required to be vested with the judiciary. And what are all the issues associated with this contempt law? Article 19 of the Constitution guarantees all citizens right to freedom of speech and expression. However, contempt clauses restrict individuals' ability to speak against the court's operation. A reasonable criticism, a mild criticism can also be construed as a contempt, can also be construed as a criminal contempt. A proceedings can be initiated. So that is one of the contentious provision. The legislation is very subjective, which means the judiciary can utilize it arbitrarily to stifle public criticism. That is what I said. There has to be a room for criticism. No organization in this democratic country is beyond criticism. Even the judiciary is subjected to criticism. You should have a thicker skin for criticism. You have to hold that. If the judiciary cannot hold this contempt, hold this criticism, they can misconstrue it as a criminal contempt and they can initiate proceedings. So that is why it is been said as subjective provision. So it will be used subjectively. So there are ways of misusing. These are the issues associated with this contempt law. So at last, to summarize that, in today's LU we have learned about Contempt of court. What is contempt of court? What amounts to contempt of court? What is civil contempt and what is criminal contempt? And why we are studying this contempt of court in current affairs session, and what are the relevant provisions provided in Constitution. Article 129 and Article 215 of Indian Constitution are the such relevant provisions which has contempt provisions. And what is the need for the courts to have such powers to punish contemptors, and at last we have studied what are the issues associated with this contempt clause. So that is all for today's session. We will meet in another polity current affairs session. Until then, stay tuned, keep watching. Thank you very much.